Back, America. It's Hugh Hewitt, now joined by Kristen Waggoner of the Alliance Defending Freedom. She is the senior counsel there. You can follow her at K Waggoner ADF. Good morning, Kristen. How are you?
Good morning. I'm great, Hugh.
Big day at the Supreme Court tomorrow for not only Alliance Defending Freedom but Harris Funeral Homes. Tell us about the case.
Well, it's a family-owned funeral home. They've been serving grieving families in the Detroit area for about 100 years. They have a professional dress code that they've abided by to ensure that their employees are essentially blending into the background and that they're focusing on families that are in the greatest time of need. The dress code prohibits tattoos and ensures they're wearing dark clothes, no flashy jewelry or hair, and is sex-specific. In 2007, a biological man was hired as the funeral director, being the front face to be working with the grieving families and greeting guests, and he agreed to abide by that dress code. But 6 years later, told Tom Ross, the funeral home's owner, that the employee would want to begin dressing and presenting as a woman at work. Tom Ross considered the different competing interests that he had of his other employees, of Stevens, the employee, and the grieving families, and determined that that wasn't going to work. The EEOC then decided to make this a test case to try to change the definition of sex discrimination under federal law to include transgender status. And now we're at the Supreme Court.
Title VII was passed in 1964. There is simply no way that the Congress of 1964 intended its protections to apply to transvestites, transgendered status, LGBTQ issues of any sort. Not a prayer that they did so. So you're not only fighting for the funeral home, you're fighting for the court's approach to statutes. Are you not, Kristen?
That is the heart of this case. The case law has said what you look at is what would the public have understood the law to mean, the term sex to mean, at the time the statute was enacted. It's not what Congress had in its mind, and it's not how someone might understand it today. It's in 1964, what did sex mean to the public?
And I cannot believe that the court will not side with you. I don't know how you lose other than an ideologically driven justice. But I want people to understand, since I've been appealing for funds for Alliance Defending Freedom all month, how long has this case been going on and what does it cost?
Oh, it's gone on for many years, including now through two administrations, because this started under the Obama administration, and as I said, the EEOC took a different position that it is taking now. Now the EEOC has sided under us, and the United States is coming in on our side. But, Hugh, I think something else, it takes a lot of effort, a lot of money to put these cases forward. But the other thing I think is important to bring out is sex discrimination also requires not only that you are taking into account whether someone is biologically male or female, but you also need to prove that one sex is treated worse than the other. And you certainly don't have that here, as all men and women are required to abide by the dress code.
And it is clearly, I think it's an easy win, but there are many other cases. If it goes the other way, if this case is lost, if Alliance Defending Freedom had not brought it, one could see every sort of 1964 Act application of the ban on discrimination between men and women applied across the board, across the United States.
Well, I think it's important to look at the drastic and widespread repercussions, and we'll be raising those with the court tomorrow. If you think about Title IX and the equal opportunity for women that it's supposed to provide, we're literally working with clients in Connecticut where high school girls have lost out because two boys are competing against them, and they've been displaced from 15 state championships in just a couple years. Or, Hugh, we've talked about the shelter in Anchorage, Alaska, where Anchorage has taken the position that this shelter must admit biological men into the women's shelter to sleep 3 feet away from women who have been sex trafficked and experienced domestic violence. And I haven't even started with the privacy implications. I have a student who's been caught undressed in a locker room, turns around to see another student of a different biological sex also undressed. And there are implications to healthcare providers, and certainly, as you know, the pronoun issue, compelled speech. It goes on and on.
Who's going to argue this tomorrow for ADF, Kristen?
John Birch is going to argue it. He's our VP of Appellate Advocacy and the former Solicitor General of Michigan.
Terrific choice. And I just want to say people are praying for you, but I want them also to contribute to you. And Kristen, it is a case on Tuesday morning. I hope you come back and tell me on Wednesday how the argument went so that we can find out, or John can join me. Are you going to be in the courtroom?
Yes, I am. We're working hard to get there and looking forward to the day.
Thank you. And I want to close by asking everyone out there, these are important cases. Please go over to HughHewitt.com. The banner is at the top. It's at the very top of HughHewitt.com. Or you can call right now, 866-700-1060.